I'm here.
Okay, I think we have all the parties present now, so we can call the case. This is Brown County case number 20 CM 1333, 20 CT 16. There's State of Wisconsin versus Martin Gemanga. State is here by Assistant District Attorney Miranda Hillman. Attorney Michael Crosby is here. Mr. Gemanga is appearing by video from the Brown County Jail. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Crosby, what is our status here today?
Thank you, Your Honor. Currently, right now, I'm only appointed on the CT file. I've spoken with Mr. Gemanga about his retaining the public defender's office on the remaining files. We're working on that as we speak right now. I've had some conversations with the DA about resolving these cases, but obviously that's somewhat tricky at the moment, given my status as counsel. However, at this point on the CT file, I'd ask that you set it out one more time. I think these cases are going to resolve. I'm optimistic that Mr. Gemanga and I spoke last night. I'm optimistic about figuring out a way to get counsel, whether it be myself or another one, a private counsel appointed to all these cases so they can get resolved.
Is there something else holding him in custody?
He's currently on, I believe he's currently sitting on a cash bail in the CM file. I believe that there was a signature bond imposed in the CT file. I think the only thing holding him currently is there's the cash bond in the CM file.
I only see signature bonds in each file. Is there a third case out there, an additional case?
The state has made reference to a case. I'm not aware of another. I'm not aware of another case. He's not on probation, Judge. If he's only on signature bonds, then he should be out. But
I'm wondering, Your Honor, there is a GPS requirement, and
that's correct.
That might be what's holding him. I don't know if there's issues paying for the GPS prior to release.
Okay, that would make sense. Yes.
Is there not okay?
We actually have a trial date already on March 10th. Did you want to keep that trial date?
Why
don't we just keep it on? He's in custody.
Yeah, I was going to say, yeah, keeping it on would be appropriate. Thank you.
So that there's a final endpoint, at least for the case. For scheduling another status conference before the trial date, how about Monday, February 22nd at 10:30?
Monday, February 22nd. That works for me, Your Honor.
Monday, February 22nd at 10:30 for another status conference. The March 10th trial date will remain on the calendar. Anything additional from the state?
No, Your Honor.
Then bond continues, and that's all for today. Thank you.
Thank you, Your Honor.
Thank you. And then I think that's the only 8:30 case. We have nothing until 9 o'clock.
Sounds good.
We have one case at 9 o'clock, Luis Baez Rios. So if you called in on that case, please just stand by for a couple minutes. It's not 9 o'clock yet.
Okay.
It is 9 o'clock, and I think we have all the parties present. Mr. Baez Rios, is that you on the phone?
Yes, I am.
Okay, I think we have everybody then. This is Brown County case numbers 20 CT 499, 20 CT 747, State of Wisconsin versus Luis Rafael Baez Rios. The state is here by Assistant District Attorney Miranda Hillman. Attorney Michael Crosby is present. Mr. Baez Rios is appearing by phone. We're doing the hearing by video and phone conference. because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Crosby, what is our status here today?
Thank you, Your Honor. These cases are proceeding. We've received offers from the state. We're working on resolving these cases. Mr. Baz needs a little more time to do some things. I'd ask that you set it out for a plea or status in 30 days so we have more time, but can resolve these cases if they resolve.
For scheduling, how about Tuesday, March 9th at 2 o'clock?
I think that works, Your Honor. Thank you.
Tuesday, March 9th at 2 o'clock. Did you hear that date and time, Mr. Baez Rios?
Yes, I did.
Anything additional from the state?
No, Your Honor.
No.
Then bond continues, and that's all for today. Thank you.
Thank you.
Thank you.
And then nothing till 9:30 now, I don't think.
All right, sounds good.
They're all interesting.
We have one case at 9:30 with Samuel Guevara. Samuel Guevara.
He's at the number ending 4069.
Okay. Attorney Guevara looks like he signed off. Okay.
What?
This is Brown County case number 20 CM 1345, State of Wisconsin versus Samuel Antonio Guevara. The state is here by Assistant District Attorney Miranda Hillman. Attorney Amani Holly is appearing. Her client, Mr. Guevara, is appearing by telephone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Holly, what is our status here today?
Your Honor, I have received discovery. I have been trying to reach out to the state as far as resolving this case or the possibility of resolving. I haven't heard back. So at this point, we'll be asking to set it for trial.
Does the state have any updated information?
The only thing I see in the file is that another set of medical records was received and it needs to be redacted by the assigned prosecutor, but there isn't an offer in the file.
With Mr. Guevara not being in custody and the charges being misdemeanor charges, it would be a really low priority case to try, and the trial calendar is getting really congested going forward. So we can schedule it for a trial. Otherwise, we can schedule it for another status if the DA's office thinks that a offer could be provided.
I can email the assigned prosecutor the notes from today's hearing.
Okay, Attorney
I
Holly,
would-
what do you think about scheduling then?
I would be asking to schedule it for a trial and then maybe a status in between the dates, since the trial will be set so far out.
The first date is March 10th. There are about 10 cases scheduled. One of them is looks like a speedy trial demand in custody, and there are several felonies. And then March 24th, there are only 5 cases scheduled, but at least 2 of them are pretty significant charges on people in custody. Then April 7th, there are 7 cases scheduled, including a felony with an individual in custody. April 21st, there's only 2 cases scheduled, but they're both felonies with individuals in custody. May 5th, there's actually no criminal cases on the calendar. May 5th, that'd be the first case date, no criminal cases. Attorney, yeah, what was your availability, Attorney Holly?
So all of the dates you listed are actually, I'm available. I just can't do May 5th. I have a CHIPS trial. But can we schedule this trial, I guess, in April? But do you have time for a status in March?
Yes, we would schedule for a status in March, yes.
Okay.
So it's April 7th or April 21st.
Which one had the least amount? I think you said one of them had 2.
April 21st.
Can we schedule for that date?
Yes. So the trial date will schedule for April 21st. Jury selection would be Tuesday, April 20th at 1:30.
What was the time?
1:30. And then a final conference on Monday, March 8th at 10:30.
I can just get 1 second. You said March 8th.
Yes, March 8th at 10:30.
I'm scheduled for a jury trial.
How about Monday, March 22nd at 3 o'clock?
I'm scheduled for a jury trial.
Is that going to go into Tuesday, March 23rd, possibly?
No, it isn't.
What about 3:30 then on March 23rd?
That works for me. Mr. Guevara, would that work for you?
Yes, that works for me.
Anything additional from the state?
No, Your Honor.
Then bond continues, and that's all for today. Thank you.
Thank you.
And then nothing until 10 o'clock now.
Very chill calendar today.
Yeah, I don't know why we just have one, but I think CCA must not have been adding anything to the calendar for today. So. We have two cases at 10 o'clock, but nobody's signing in yet, so we'll stand by for a couple minutes.
Sounds good.
We have two cases. I think Attorney Reitz, your client is here. I don't see Attorney Crosby's client. So if we have Mr. Fish, we can call your case right now. Bernard Fish,
Hello, how you doing there?
good. Can you turn the video on?
Oh, okay.
Okay, now we can see you. This is Brown County case numbers 20 CF 548, 20 CF 831, State of Wisconsin versus Bernard Allen Fish Jr. The state is here by Assistant District Attorney Miranda Hillman. Attorney Brett Reitz is here. Mr. Fish is appearing by video conference. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Reitz, what is our status here today?
It's not resolved, and my client is still participating in treatment. And I think that more and more, this is a case I think should go into the drug court.
Has an application been submitted?
You know, and I apologize. I do not believe so.
Okay. The sooner you get an application in, the sooner it can be reviewed, obviously. The DA's office would first do a legal screen to make sure there aren't any automatically disqualifying offenses. And if there are none,
Sure.
passed on to the full team to do a treatment evaluation as well. And
10-4.
I'll give you time to do that.
Is there a specific website I can go on? for that?
I'll talk to you.
Okay, all right.
I believe there is a Brown County Drug Court website where it's available online.
Okay.
For scheduling, how about
Or this one.
Monday, March 8th at 3:30?
You have a pretrial for county at 3,
Zoom.
but Zoom,
Yes, I can do that.
Monday, March 8th at 3:30. Did you hear that, Mr. Fish?
Yes, I did, sir.
Bernard, call me, please.
Okay.
And then there is a CJS violation report that was submitted. It does appear that Mr. Fish voluntarily disclosed that he did have a relapse event, and he indicated that he resumed sobriety after the relapse event and is continuing to work with his team to maintain his sobriety going forward. I just commend you for voluntarily disclosing that. I mean, it's much better to voluntarily disclose that than to be caught. ADA Hillman, does the state have any position on it?
No, Your Honor.
Okay, Attorney Reitz, did you want to add any comment on it? I guess what I'm leaning towards is maybe requiring him to do 2 urine tests a week in response to it.
You know, he's involved in aggressive rehabilitation. The addiction he's fighting in a way successfully. People do relapse, was significant, and I mean, he's in an environment, and also because he's self-reported, is consistent with his acceptance of responsibility and his lack of denial. So I don't believe a urine test would be required.
Okay.
Had he been caught, had he not self-reported, I would have a different position.
Does he get urine tests right now?
I don't.
Through Oneida Behavioral Health, yeah.
Okay, how many a week do you get?
Well, it's once every 2 weeks.
And are they provided to the CJS supervisor?
She's in contact with my counselor, yes, but
It's once every 2 weeks?
yeah.
Okay. I'm going to require you to do 1 urine test per week then,
1 per week.
as a response to the relapse.
Okay.
And that's as an alternative to potentially having your bond revoked. We're just going to respond to it that way instead. You can either do it. You can either do it with the who are you giving the urine test to right now?
Oneida Behavioral Health.
Okay, so it can either be done with Oneida Behavioral Health or with Criminal Justice Services, as long as Criminal Justice Services is receiving the information from the test. Okay, try to urine screen once a week. Anything additional from the state?
No, Your Honor.
Attorney Reitz, anything else for today's purposes?
No, thank you today. Thank you for your work today. Thank you.
Then that's all for today on this case. Thank you.
Thank you.
Attorney Crosby, we do have a couple people signing in. Let's see if those are your clients.
She was having a little trouble with the Zoom. I just spoke to her.
Okay. Babiar's is at 10:30. Let's find out who's on the other device. Ginger Claggett. Ginger Claggett. Looks like it's still connecting.
Honestly, Your Honor, she may have not figured out how to press the use internet audio button.
Okay. What are we planning on doing? Anything other than scheduling?
No,
Okay.
I think this is one of the first appearances in the branch that I've been on the case.
Do you want to? We can try calling her and routing her in just by telephone number.
That actually might work. I've got a phone number that I can give you.
Okay, you can say it right now.
It's 920-634-6949. She may not pick up though, honestly, if she doesn't recognize the number.
Yeah, it went to voicemail. So I don't know if you want to try calling her yourself then.
Yeah, I can.
Mr. Babiars, your case is at 10:30. Are you able to mute your device?
Oh, yeah, sorry.
Okay, yeah, the camera's off, but the sound was still on.
Your Honor, can I ask that the court clerk call her again? She'll pick up and then she can push through. I didn't want to have to go like my cell phone through the Zoom and stuff like that.
Okay, we'll try again.
I told her that you'd be calling and she'll probably pick up.
Ginger Clagett?
Yes.
Okay, we're gonna call your case right now. This is Brown County case number 20CM16, State of Wisconsin versus Ginger Burnett Clagett. The state is here by Assistant District Attorney Miranda Hillman. Attorney Michael Crosby is here. Ms. Clagett is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom. For everybody's health and safety, we are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Crosby, what is our status here today?
Thank you, Your Honor. At this point, this case is still ongoing. I don't think I've received discovery yet. I may not have. I was only appointed recently. I would ask that you set this case out another 30 days for I guess a plea or a status, just to keep our options open, and then so that we can try to resolve this case.
How about Monday, March 8th at 10:30?
Is there a chance we could do a different day, Your Honor? I've got a trial scheduled that day.
What about Tuesday, March 9th afternoon?
That works.
How about 3 o'clock?
Yes, I think that works.
Tuesday, March 9th at 3 o'clock. Anything additional from the prosecutor?
No, Your Honor.
And Ms. Clagett, did you hear that date and time?
Yes, I did, Your Honor.
Anything additional, Attorney Crosby?
Nothing further from me, Your Honor. Thank you for working with us on the appearance.
Yes. Bond continues, then that's all for today. Thank you.
Thank you. Thanks, Ms. Clagett.
Thank you.
And then there's nothing until 10:30.
Okay.
And you can hang up, Ms. Colgate.
Thank you so much. Have a blessed day.
Thank you.
Hello?
There are no cases until 10:30, so if you could please mute your device until your case is called. Thank you. It is 10:30. We have 5 cases scheduled at 10:30. If there are attorneys who are just doing scheduling on your case, we can do those first to get them taken care of. Attorney Zillis or Attorney Gonzalez, Attorney Turner.
Your Honor, we're planning on doing clean sentencing this morning, so we can wait.
Your Honor, Attorney Gonzalez and Mr. Babiars are just going to be scheduled.
Okay. Attorney Turner
Good morning, Judge. I believe we'll just be scheduling today as well.
and Attorney Stock.
I think we'll be scheduling, but can I have a brief breakout with Michaela?
Yes, I can do that. Attorney Stock, you need to turn on your camera too. Okay, Michaela Kitson, if you could accept the prompt to go into the breakout room with your lawyer. David Babiars, if you could turn on your camera. Okay, there you are. This is Brown County case number 20 CF 763, State of Wisconsin versus David Michael Babiars. The state is here by Assistant District Attorney Miranda Hillman. Attorney Jason Gonzalez is here. Mr. Babiars is appearing by video. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Gonzalez, what is our status here today?
Thank you, Your Honor. I did receive an evidence.com link with the discovery. However, I still need to discuss this further with Ms. Lemkel, who's the assigned prosecutor. I guess at this point, Your Honor, I'm not sure if you're willing to give us one more status. I believe this is our first. Otherwise, we could set it for trial, and I can continue to try to negotiate with Ms. Lemkel.
Yes, we can do another status. How about Monday, March 8th at 1:30?
That works.
Monday, March 8th at 1:30. Mr. Babiars, can you confirm you heard that date and time?
March 8th at 1:30?
Yes.
Correct. Thank you.
Anything additional from the state?
No, Your Honor.
Then bond continues, and that's all for today. Thank you.
Thank you.
Thank you.
Brogan Hyde.
Yes, Your Honor.
This is Brown County case numbers 19 CM 1293, 20 CM 66, 21 CM 16, 21 CM 23, 21 CM 24. They're all State of Wisconsin versus Brogan Alexander Hyde. The state is here by Assistant District Attorney Miranda Hillman. Attorney Michael Turner is here. Mr. Hyde is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Turner, what is our status here today?
Thank you, Your Honor. Since last time we were in front of the branch, Mr. Hyde has had 3 new cases that were charged out, 2 that were pretty old referrals, if I'm correct, and 1 new case around Christmas. We don't have a global offer to resolve the files. We had an original offer on the first 2 cases, but I do need an updated global offer to see if we can get these matters resolved. We currently have a trial calendar date on February 10th. I'm comfortable at the discretion of the court and the state to either keep that date on or possibly set another date prior to that to see where we're at as far as a possible global resolution.
There are 2 cases scheduled that day that have very serious felony charges, including one that's a speedy trial demand. So if that case goes, it would certainly be the top priority. Mr. Hyde, it does look like he's posted cash on these cases, so he's not in custody. So I think I would favor taking the case off the jury trial calendar because, to be honest with you, with the state of the pandemic, I might not allow a trial to go forward on somebody that's not in custody anyway in 2 weeks. Attorney Turner, did you want to comment further on it?
I would be comfortable going forward in that manner too. And then Attorney Hillman, if you could just have the DA assigned to this case, try to reach out to me with the global resolution, that would be excellent.
Send an email.
ADA Hillman, did you want to comment on the taking the trial off the calendar?
No, Your Honor.
Okay, then I'm going to remove the trial date. That's February 10th. So that date is off the calendar, as well as the jury selection the day before, of course. And then we'll schedule for a status conference instead. How about Tuesday, March 9th at 1:30?
I have a 1:45, so that might be cutting it close. Do you have anything earlier?
How about 8:30?
That would work.
And then Mr. Hyde, I believe that criminal justice services compliance is required of you. I do not see any indication you are not in compliance, and they usually are pretty prompt sending something if there's a violation. So continue to comply with criminal justice services. Okay, Mr. Hyde?
Of course, Your Honor.
Okay. And you have so many cases pending that if you fail jump again, I'm probably going to forfeit the cash bond, okay?
All right. And what you were just saying, I have a felony case?
No, I was referring to a different case that was scheduled for February 10th.
Oh, okay. I'm sorry.
Anything additional from the state?
No, Your Honor.
Attorney Turner, anything else for today's purposes?
No, Your Honor. Thank you.
Then bond continues, and that's all for today. Thank you.
Thanks. Have a good day.
Thank you, Your Honor.
Attorney Stock, are we ready on your case?
Yes, we are, Your Honor.
Is it just going to be scheduling?
Yeah, we're going to be scheduling a plea.
Oh, actually, we lost your client. She's signing back in right now.
Yeah, we got it resolved. We're just going to be scheduling a plea.
What are we doing on your case, Attorney Mongen?
We will be scheduling a plea/status hearing.
Okay.
I know today we have the arraignment.
Okay. We can call Michaela Kitson right now. If you could start your video and mute your device. Okay, we can see you. If you can mute the device too. Are you in the courthouse right now, Ms. Kitson?
Yeah.
Okay. I just muted your device just to eliminate the background noise. This is Brown County case number 20 CM 267, State of Wisconsin versus Michaela Sophia Marie Kitson. The state is here by Assistant District Attorney Miranda Hillman. Attorney Matthew Stock is appearing by video. Ms. Kitson is appearing by video. She is located in the courthouse though. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom. for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Stock, what is our status today?
I believe we're resolved, Your Honor. We just have to get the paperwork done. So we'd be looking for a court date relatively soon to get the plea done.
How about Friday, March 12th at 2:30 or 3:30?
That'll work.
Which one?
Available.
Friday, March 12th at 2:30 then we'll pick. For plea and sentencing. Ms. Kitson, if you could unmute your device just to confirm that you heard the date and time.
Yeah, I heard them.
Anything additional from the prosecutor?
No, Your Honor.
Okay. That will be by this same video conference procedure, Ms. Kitson, just so that you're aware.
Okay, but will that be the last court date?
If the case is going to be resolved that day, it would be yes.
Okay.
But make sure you stay in contact with your lawyer, Attorney Stock, so that he can review the case with you. Anything additional, Attorney Stock?
No, Your Honor.
Then bond continues, and that's all on Ms. Kitson's case.
Thank you.
Then we'll
Stop.
call Naomi Skenendor. Did you have another question, Ms. Kitson?
Yeah, I'll just call him after this. Thank you.
Okay,
Okay.
Thank you.
Thank you.
Naomi Skenendor? Naomi Skenendor? Naomi Skenendor?
That would be my client, Your Honor. I do not see her. I'm checking the phone.
So you want to try calling her then? There's 2 telephone call-ins on here with only 2 cases left. Anthony Vaughn? Anthony Vaughn?
Yes. Yes.
Okay. Attorney Zillis. Well, why don't we call your case because we don't have Ms. Skenendor, unfortunately. This is Brown County case numbers 20 CF 654, 20 CF 1129, State of Wisconsin versus Anthony Keon Vaughn. The state is here by Assistant District Attorney Miranda Hillman. Attorney Paul Zillis is here. Mr. Vaughn is appearing by phone. We're doing the hearing by phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public, no one in the courtroom gallery. And I think there may be a third file scheduled for today. Is that correct, Attorney Zillis?
That's correct. That would be 20 CF 1955.
Okay, and that's on for an arraignment?
Right, but that is what we're anticipating today is just resolving all 3 files at the same time. We have an offer. I have filed the plea questionnaire waiver of rights form along with the associated documents.
Okay.
Your Honor, since there's a victim on the case, I don't know if call-in user 1 might be a victim, but because it was set for an arraignment, I would want to make sure that the victim's present. So they wouldn't have been informed that this is a potential plea and sentencing.
Okay, thank you for that notification, because that could be the case because we have an additional person calling in. It is a felony plea, Attorney Zillis?
That is correct. The settlement agreement does not anticipate a PSI.
Okay. Unfortunately, I think I'm going to require that he at least appear by video. And if he doesn't have access to video capability, then we would have to do it in the courtroom.
Okay.
Mr. Vaughn, do you have access to, if I give you another court date, do you have access to a device with video capability?
Yes.
Okay, so if I gave you another date, you would be able to make those arrangements to appear by video so I can see you?
Yes.
Okay. Well, let's complete the arraignment then on 20 CF 1955. Attorney Zillis, have you received a copy of the information?
I did, Your Honor. It mirrors the complaint, so we'd waive reading of the information and enter not guilty pleas at this time on all charges.
Okay. So, Mr. Vaughn, we're just doing the arraignment right now, where your attorney is just going to enter a not guilty plea on your behalf. You do have a right to be present in person for the arraignment also. Are you willing to waive your right to be present in person for the arraignment so we can continue with the phone conference?
Yes.
Okay, thank you. I will enter the not guilty plea into the record on 20 CF 1955. I'll look at the calendar for scheduling.
Do you have time on the 12th, Your Honor? That was a date you just gave.
The 12th of March?
Oh, I thought it was the 12th of February.
Did I say February in this case? I didn't, okay. It was Friday, March 12th. I do have a time slot at 3:30 on that date. If you want to look at your calendar for a starting point.
Okay, is that the soonest you'd have, Your Honor?
Let me look at February 12th.
Because February 12th does work for me, but if we got a time earlier, that'd be great.
We could try 11 o'clock.
On the 12th?
February 12th, yes.
Okay, that's fine. That's Anthony. Does the morning work on the 12th? That's a Friday.
Yeah, I mean, I normally work, but I'm sure I can take a break and get this handled.
Okay, yeah, this is around lunchtime, so that would work. So 11 o'clock, is that what you said, Your Honor?
Friday, February 12th at 11 o'clock, yes.
Okay, that'll work.
So, Mr. Vaughn, you need to be able to invest some time into appearing by video conference. And I need to make sure that your entire attention is focused on the court appearance, okay?
Okay.
If there's anybody here who is a victim on any of these cases and wants to be heard on scheduling, now is the time to address the court. You are free to continue to remain silent if you choose to do that. And there's no response. Anything additional from the state?
No, Your Honor.
Then bond continues, and that's all for today on this case. Thank you.
Thank you, Your Honor.
Thank you.
Naomi Skenendor. Naomi Skenendor. Any luck, Attorney Manjan?
No, Your Honor.
Naomi Skenendor. Naomi Skenendor. If you just called into the court, if you could mute your device to reduce the background noise, that would be appreciated. Sometimes *6 will act as a mute button. *6. If you could please mute your device. This is Brown County case numbers 18 CF 834, 19 CF 719, 19 CM 355, 19 CT 995, 20 CF 1791. They're all state of Wisconsin versus Naomi Renee Skenendor. The state is here by Assistant District Attorney Miranda Hillman. Attorney Andrew Manjan is present. Ms. Skenendor does not appear. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Ms. Skenendor does not appear on the video conference or in the courtroom. And like I stated, she would be able to walk into the courthouse unrestricted and up into my courtroom, and she does not appear here. Attorney Manjan, have you had recent contact with your client?
No, I have not.
ADA Hillman?
State requests a bench warrant.
And I don't believe this is the first time we've had trouble having Ms. Skinnendorf reliably coming to court. So I think I'm just going to issue the bench warrant forthwith at this point. And then that's all on Ms. Skinnendorf's case. Thank you.
Thank you, Your Honor.
And then there's nothing until 11 o'clock at this point.
Sounds good.
If you could please mute your device if you just called in. Sometimes *6 will act as a mute button. *6. We don't have any cases until 11 o'clock, which is about 5 minutes from now. It's just about 11 o'clock. We have 4 cases scheduled at 11 o'clock.
Good morning.
Good morning.
How are you?
I'm doing well, thank you.
Excellent.
This is,
Ed Oliveira.
oh yeah, Mr. Oliveira, I see your name on there. We're just waiting for a few other.
Yeah, no worries.
Sign in.
Thank you so much.
Thank you.
I appreciate it.
Attorney Johnnon, are you doing anything other than scheduling today on that case?
No, Your Honor, we are entering a plea today.
Oh, you are, okay. We might take you last then, depending on what's gonna happen in the other cases.
That'll be
Attorney
fine, thank you.
Hassel, what are we doing on your case?
I think today is just going to be a status and
Okay.
scheduling.
Attorney Kane, what are we doing on your case?
Just scheduling, Your Honor.
And Attorney Zhang, what are we doing on your case?
I believe it's just a reschedule.
Okay, we'll call the cases that are just gonna be rescheduled first. Chauncey Hughes. Chauncey Hughes. James Jonovan.
Yes, sir.
We'll call that case with Attorney Zhang. This is Brown County case number 20 CF 790, State of Wisconsin versus James Allen Jonovan. The state is here by Assistant District Attorney Miranda Hillman. Attorney Kim Zhang is here. Mr. Jonovan is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Zhang, what is our status here today?
Thank you. I would just ask for a reschedule. I just need a little bit more time to speak with my client.
How about a status conference on Tuesday, March 9th at 1:30?
I'm in jury selection at that time. Don't remember what branch it was for though. No, it's for your branch. So
You want to schedule it at that time then?
yes, that would be fine.
Tuesday, March 9th at 1:30. Mr. Donovan, did you hear that date and time?
Yes, Tuesday, March 9th at 1:30?
Yes.
Okay, then.
Anything additional from the state?
No, Your Honor.
Then bond continues, and that's all for today. Thank you.
Thank you.
Okay, yep.
Morgana Hyde.
Yes, Your Honor.
This is Brown County case number 20 CF 101, State of Wisconsin versus Morgana Adara Hyde. The state is here by Assistant District Attorney Miranda Hillman. Attorney Brian Kane is appearing. Ms. Hyde is appearing by phone, I believe. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Kane, what is our status today?
Judge, we just need a bit more time. We're trying to coordinate the potential resolution with another case in another county of Ms. Hyde's. It looks like on my calendar that March 9th date would work. I likewise, like Attorney Zhang, have jury selection in your branch that afternoon. Otherwise, I'm free in the morning as well.
How about 3:30 on Tuesday, March 9th?
That should be fine with me.
Tuesday, March 9th at 3:30. Did you hear that date and time, Ms. Hyde?
Yes, I did.
Anything additional from the prosecutor?
No, Your Honor.
Then bond continues, and that's all for today. Thank you.
Thank you.
Attorney Manjan, what are we doing on your case? Attorney Manjan,
Yes, Your Honor.
what are we doing on your case?
We were planning on scheduling a plea/status hearing.
Okay. Angel Ariola,
Your Honor,
Present.
okay.
okay, you're on the telephone?
Yes, sir.
Okay, I see your feed now. This is Brown County case numbers 20 CF 1095. Let's back up. This is Brown County case numbers 20 CM 1095, 20 CM 1340, 20 CT 436, 20 CT 498, 20 FO 88, 20 TR 1344. They're all state of Wisconsin or Brown County versus Angel Robles Ariola. The state is here by Assistant District Attorney Miranda Hillman. Attorney Andrew Manjan is present. The defendant is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Manjan, what is our status here today?
Thank you, Your Honor. I've appeared before on these cases. I believe this is the first hearing where we've had all the cases called together. I've received discovery for most of the cases. We have a global offer as well. I would ask for a status/plea hearing just to give us time to complete the discovery review and possibly resolve these cases.
How about Friday, March 12th at 3:30?
That's the third day of a trial in Branch 7. I think that would work, though.
Friday, March 12th at 3:30. Anything additional from the state?
No, Your Honor.
Then Mr. Ariola, can you confirm that you heard that date and time?
Friday, March 12th at, was it 3:30?
Yes.
Yep.
Then bond continues, and that's all for today. Thank you.
Thank you.
Thank you, Your Honor.
Your Honor, my client is now here. He's listed under Mo White, which is actually his artist name.
Okay. Chauncey Hughes?
Yes.
Chauncey Hughes, can you confirm that you can hear me?
Yes, I can hear you, Your Honor.
Okay. This is Brown County case numbers 20 CF 1388 and 20 CF 1430. They're both state of Wisconsin versus Chauncey Marlon Hughes Jr. The state is here by Assistant District Attorney Miranda Hillman. Attorney David Hassel is here. Mr. Hughes is appearing by the Zoom video conference. Are you able to start your video so we can see you, Mr. Hughes? We can hear you, but we can't see you. Okay, now we can see you. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Hassel, what is our status here today?
Thank you, Your Honor. We have been proceeding in this case, thinking that it would go in line with some matters pending in other counties. It's now become apparent that is not likely to occur. And so we will need, I will be filing some motions and some discovery soon that will require their own dates, but it might make sense to schedule out a status. And it sounds like 2 months is about when the court's rescheduling now.
It'd be March 8th or March 9th for a status conference. We can do Tuesday, March 9th at 1:30. Otherwise, there's more dates available on the 8th.
I can do the 9th at 1:30 or anytime on the 8th.
Tuesday, March 9th at 1:30 then. Mr. Hughes, can you confirm that you heard that date and time?
March 30 p.m. March 9th at 1:30 p.m. You said?
Yes. ADA Hillman, anything additional?
No, Your Honor.
Then bond continues, and that's all for today. Thank you.
All right. Thank you, Your Honor.
And now we have Mr. Oliveira's case.
Yes, good morning.
This is Brown County case number 20 CT 961, State of Wisconsin versus Edward Anthony Oliveira. The state is here by Assistant District Attorney Miranda Hillman. Attorney Zasha Janin is here, and we have Mr. Oliveira appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Janin submitted a plea questionnaire and waiver of rights form along with a jury instruction. It looks like the plan is to plead no contest to count 1, operating a motor vehicle while intoxicated, second offense. Is that your understanding, Attorney Janin?
Yes, Your Honor, it is. Thank you.
And ADA Hillman, is that your understanding?
Yes, Your Honor.
And Mr. Oliveira, is it your intent to enter a no contest plea to operating while intoxicated, second offense?
Yes, it is. Thank you, Your Honor.
And Attorney Janin, how did you review the plea form with your client, in person or some other way?
Your Honor, it was sent to him electronically in advance, and then we discussed it over the phone.
Correct.
That's correct, Mr. Oliveira?
Yes, it is. Thank you, Your Honor.
Do you need any additional time to review the plea form with your lawyer?
I don't believe I do.
Do you need any additional time to review the criminal complaint with your lawyer?
No.
And ADA Hillman, this does not appear to be a case that requires victim notification, correct?
Correct.
And Attorney Janin, did you review the jury instruction with your client as well?
We talked through the elements, yes.
Okay.
Mhm. Correct.
And then did you talk to your client about making the video conference appearance here today instead of being in person?
We did not talk in detail. If the court wants to confirm that, that's fine with him. That's fine by me.
Okay. Mr. Oliveira, you do have a right to be present in person in the courtroom for a plea and sentencing hearing. First of all, are you able to see me and hear me clearly?
I am, yes. Thank you, Your Honor.
And I'm able to see you and hear you clearly as well. We're doing these hearings by video conference because of the public health emergency. The easiest way to comply with all the public health guidelines is to do as many of these hearings as we can by video conference. Are you willing to waive your right to be present in the courtroom so we can continue with this video conference?
Yes, I am.
Okay. If it becomes necessary to talk to your lawyer privately at some point, we can accommodate that with this video conference procedure. One required warning I have to give you is that if you are not a citizen of the United States of America, you are advised that a plea of guilty or no contest for the offense with which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law. Do you understand that, Mr. Oliveira?
I do. I am a citizen of the United States, so
Okay.
I'm not worried.
Okay. According to the plea form, you are 49 years old. Is that correct?
That is correct.
And you do have a high school diploma. Is that correct?
That is correct, and a bachelor's degree.
Okay. I see it says 16
Oh,
years.
sorry.
You do have a bachelor's degree?
I do.
Okay. And you do understand English, it sounds like, correct?
Correct.
According to the plea form, it says you are not currently receiving treatment for mental illness or disorder. Is that correct?
That is correct.
And you have not had any alcohol, medications, or other drugs in the last 24 hours. Is that correct?
Outside of the medication that I need for my underlying health conditions, which are diabetes, high blood pressure, et cetera. Yes.
Okay. Do any of those medications do anything to affect your brain, your ability to understand?
No,
Okay.
they're all, yeah, no, they do not.
And you're taking them all as prescribed according to the directions?
Correct. And I can provide the court with a listing of those if necessary.
That's not necessary, no. I just need to make sure that you can understand what we're doing today. That's the only.
Oh, sure, sure. Yep, no, I get it.
Count 1 is a misdemeanor. It's operating a motor vehicle while under the influence, second offense. The maximum penalty is 6 months jail or a $1,100 fine or both. Do you understand that's the maximum penalty?
I do.
There's also a minimum penalty of 5 days jail and a $350 fine. Do you understand that's the minimum penalty that's required?
I do.
Do you understand that I don't have to go along with any plea agreement or any recommendation, and I could sentence you up to the maximum penalty? Do you understand that?
I do, Your Honor.
Your attorney included the jury instruction that has the elements. The elements of this offense are, first, that you drove or operated a motor vehicle on a highway. Second, that you were under the influence of an intoxicant at the time you drove or operated a motor vehicle. You understand those are the elements of operating while intoxicated?
I do.
The state asserts that you have one prior conviction for operating while under the influence.
Correct.
That was an offense date on February 10th, 2014, and a conviction date on September 22nd, 2014. Do you agree you have one prior conviction for an operating while intoxicated offense?
I do, in the Commonwealth of Massachusetts. Yes, I do.
Okay. And you understand that because you have that prior conviction, that's what makes this a criminal second offense. Do you understand?
I do.
The criminal complaint outlines the facts that the state believes are true. Do you agree that there are enough facts in the criminal complaint to support your plea to this offense?
Yes.
Attorney Johnnon, do you agree with that as well?
Yes, Your Honor, thank you.
And I've independently reviewed the criminal complaint, and I will find there is a sufficient factual basis for a plea to this charge. The plea questionnaire outlines your constitutional rights. They are the right to a jury trial where all 12 jurors would have to agree that you're either guilty or not guilty. Your right to remain silent, your right to testify and present evidence, your right to use subpoenas to require witnesses to come to court, your right to confront and cross-examine witnesses who would testify in court, and your right to make the state prove that you're guilty beyond a reasonable doubt. You understand that you'd be giving up all those rights by entering a no contest plea?
I do.
Do you understand that if I accept your no contest plea, I will find you guilty of the offense?
I do.
Are you doing this of your own free will?
I am, Your Honor.
Has anybody put any pressure on you or forced you to make this plea?
No, Your Honor.
Do you have any questions about anything that we've talked about so far?
Not thus far.
And you have had sufficient time to review the plea form with your lawyer?
I have.
If you were meeting with your lawyer in person to review it, would you have signed the document verifying that you reviewed it?
I would have.
Attorney Johnnon, are you satisfied that your client is freely, voluntarily, intelligently, and knowingly making this plea?
I am, Your Honor, thank you.
Are you satisfied that he understands the elements, the facts, and the rights that he is giving up?
I am so satisfied.
And Mr. Oliveira, are you prepared to enter a plea at this time?
I am.
Then in count one, to the charge of misdemeanor, operating a motor vehicle while intoxicated, second offense, what is your plea?
Guilty.
The plea form checks the option for no contest, and
I'm
Attorney
sorry, I
Johnson-
should have, I should have said no contest.
Yeah, Attorney Johnson, your client wants to plead no contest, correct?
That's correct, Your Honor. Thank you.
I apologize.
It's no problem. I am going to restate it though, just so that's clear for you.
Yep.
The form does have checked no contest, just letting you know that. It has to count one, misdemeanor, operating a motor vehicle while intoxicated, second offense, what is your plea?
No contest.
I will accept the no contest plea. I'll find that it's been freely, voluntarily, intelligently, and knowingly made, that Mr. Oliveira understands the elements of the crime that we reviewed here today in court, the facts that support the elements that are described in the criminal complaint, and he understands the rights that he is giving up that we've also reviewed here today in court. I will find him guilty of the offense and order a judgment of conviction entered into the record. And then we'll move to sentencing. What is the state's recommendation?
Your Honor, I just want to confirm with defense counsel that this is a joint recommendation.
That's correct. Thank you.
Thank you. So then in exchange for the defendant's plea, the state and the defense are jointly recommending the left-sided guidelines for a .212 BAC. More specifically, we're recommending 60 days jail, a $650 fine plus costs totaling $1,807, a 15-month driver's license revocation, 15-month IID, AODA, and a $46.50 blood draw fee. The defendant's prior record only includes his prior OWI, which was mentioned, is from 2014. The circumstances involved in this case occurred when Officer Schrader was dispatched to a reckless driver on I-41. The caller stated a black SUV was swerving all over the road, went into the ditch, and hit a sign. When Officer Schrader located this vehicle, it was traveling about 40 to 42 miles per hour in a 45 mile per hour zone. There was a traffic stop, and the defendant was the driver. He had multiple indications of impairment, did poorly on the standard field sobriety tests, consented to the blood draw, and as was stated, his BAC was a .212. Now, this is a serious offense, as all OWIs are. Anytime someone gets behind the wheel of a vehicle while under the influence, they're not only putting themselves in danger, but anyone on the roadway. And here we have very aggravated driving. The caller talked about the defendant going into a ditch and hitting a sign, which is concerning. However, the defendant is here accepting responsibility for his actions. He appeared to be cooperative with the officers and throughout the investigation. His last OWI isn't the most dated that we've seen, but also isn't the most recent that we've seen. All too often we see within the past 2 or 1 years for a prior. So given all of that, the state believes that the left-sided guidelines are appropriate in these circumstances and asks the court to adopt the joint recommendation. Thank you.
Thank you.
Thank you very much.
Attorney Johnson?
Thank you, Your Honor. Well, this is a case where Mr. Oliveira comes now before the court with 2 OWIs too many. The good news is that he knows that. He is taking full responsibility, and during these times, he could have pushed this out until 2025, maybe, depending on how jury trials go, but he didn't want to do that. I can tell the court that, well, Mr. Oliveira is still a young man. He's just knocking at the big 5-0, but
I appreciate that.
He's a young man. He is someone who was cooperative during this investigation. The only thing that I would add to the circumstances here was that the PBT was significantly lower at the scene. I believe it was a 0.14, but that just...
I'm not even sure it was that high, to be honest.
But, Your Honor, I think Mr. Oliveira is a...
Mr. Oliveira, we do have a court reporter that's writing everything down. So we do have to talk one person at a time.
Oh, I'm so sorry, Your Honor.
So let
I apologize.
The state made their recommendation. Your lawyer's making a recommendation right now. And then I am going to go to you and you're free to comment as well. Okay.
Okay, I'm sorry, Your Honor.
Okay, Attorney Johnson, if you could continue.
Thank you, Your Honor. And well, Mr. Oliveira works as a manager at Fleet Farm. Currently, he's working from home. One thing I can tell the court that this is not someone who goes to jail regularly. I'm sure the court has many people appearing that going in and out. And frankly, 60 days is nothing for them. But I can tell you for Mr. Oliveira, this is a significant penalty, something that's going to leave a lasting mark on him and a lasting impression. He is very concerned because of his health issues that he had previously mentioned about the jail portion. And while I don't enjoy him going through that, I think it's important for the court to know that this is someone who's taking it seriously, who knows that he has to pay his penalty, and he is doing that in this case. And Your Honor, for all these reasons, we're asking the court to adopt the joint recommendation. Thank you.
Thank you. So now, Mr. Oliveira, is your opportunity to address the court if you choose to do so.
Yes, Your Honor. So, I will focus on some of the things that my attorney said. I've never been in jail before, even, from my first offense. I'm going through a divorce right now, and I need to provide for my family. So any mercy that the court could allow me would be very much appreciated. And as my attorney said, I am working from home just about all the time. I would say 95% of the time. So, and I have an office job. So, it's easy for me to work from home, especially during the pandemic. And I just ask Your Honor, to take that into effect. And I appreciate any leniency you could give me, but I am taking responsibility. I did wrong, and I need to pay the penalty.
Thank you.
Thank you, Your Honor.
When I issue a sentence, I have to consider the protection of the public, gravity of the offense, rehabilitative needs of the defendant, character of the defendant, and deterrence of others, then apply the Gallian sentencing factors to those sentencing objectives. In terms of past history of criminal offenses and history of undesirable behavior, it sounds like it's just limited to the prior OWI first from 2014, I believe it was.
That's correct, Your Honor. And that DUI was found to be a continuance without finding, which I think might be something that's unique to the Commonwealth of Massachusetts.
Okay. I do need you to be quiet at this point, because
I'm sorry.
Remember, I said the court reporter has taken everything down, so we need to have one person talking at a time.
Okay, I'm sorry, Your Honor.
Thank you. The prior OWI first was in 2014, which is probably a larger time difference than we normally see between OWI offenses, but it's not an incredibly large amount of time between the two. Mr. Oliveira, he's 49 years old. It sounds like he has a pretty consistent work history managing Fleet Farm. He does have a high school degree and a bachelor's degree as well. He has accepted responsibility for the offense by coming in to enter a no contest plea, and his demeanor here in court today has been very pleasant, and he does appear to be remorseful for the offense. The nature of the offense, though, is significant. One OWI offense puts the entire community at risk, and now this is the second conviction that you have. And factually, in this case, if the witness's statement, according to the witness's statement, I mean, it was pretty dangerous driving behavior, Mr. Oliveira, to deviate that much from your lane of traffic. I mean, it's really by luck, by chance, that you didn't hit another vehicle, injure another person, and worse yet, kill another person. And that's what the community, what parents in this community really fear about drunk driving, is just the randomness of it, and a vehicle that weighs thousands of pounds having no one controlling it because you're intoxicated. So, and if you would have injured somebody or worse yet, killed somebody, we'd be talking about a totally different case where I would have a victim's family here in the courtroom telling me to send you away as long as I can. And you're very fortunate that didn't happen. So we're just looking at a pretty standard drunk driving case. Mr. Oliveira has never been to jail, so at any jail penalty is going to be a significant penalty for Mr. Oliveira. One additional thing I would add for you, Mr. Oliveira, is that you're not going to be on probation. This is just going to be a straight jail sentence according to the guidelines. So there's not going to be any probation agent making sure that you do the AODA assessment and you follow through with any treatment that's available to you. It's going to be on you to do those things. And the importance of doing that is that the penalties for each one of these successive drunk drivings goes up. So for the third offense, the penalties go up. The maximum penalty and the minimum jail penalty go up. And then if you get 2 more and it's a 4th offense, that's a felony. An OWI 4th is a felony. And then you're talking about losing your constitutional rights because of a felony conviction, and you'll always be labeled a felon with that. So my point of telling you that is that you're 49 years old, you have a lot of life to live, and you need to get a handle on this now. And like I said, there's gonna be no probation agent enforcing whether you're drinking or not, but your goal should be to voluntarily never drink anything again so that you don't risk getting that 3rd and 4th offense. So I hope that is the goal for you going forward. Well, when I consider all of the positive and the negative factors in this case, I do think that this is just a straight left side guidelines case, according to the joint recommendation. The sentence will be 60 days jail. That's with Huber and good time. You can report within 60 days. $650 fine for a total of $1,807 total. And I think one of the penalties that the state legislature uses as a deterrent is a significant financial penalty in these OWI cases. 15 months revocation of driver's license, 15 months of the ignition interlock device, a blood draw fee of $46.50, and an AODA assessment and follow through with recommendations. The blood draw fee of $46.50, that has to be paid within 30 days. The $1,807 total fine, that has to be paid within 6 months, or set up a payment plan with the clerk of court's office. So if you get to 6 months and you haven't paid it off yet, don't just ignore it. Make sure you set up a payment plan with the clerk of court's office.
Right.
And then Attorney Johnin for a report date within 60 days. Did you talk to your client about that?
Yeah, I'm not sure what Mr. Oliveira prefers. Generally, my standard is just to put it out 60 days, but I'm not sure if Mr. Oliveira.
I mean, to be honest with you, I would prefer to, get that done sooner rather than later.
Attorney Johnin, is the Huber aspect of it taken care of yet, though?
It's not yet, and so
Okay.
I was going to ask the court about whether there needs to be something in the judgment of conviction as far as electronic monitoring, or if that's just going to be done automatically by the sheriff's department.
I think it's totally the discretion of the sheriff's department on the electronic monitoring. I certainly don't object to it, but it's up to the sheriff's department to whether they allow it or not.
And if we pick a date, obviously he can come in sooner. Is that right?
Yes, but he has to contact the jail ahead of time. I think that's correct. Okay, he can't just show up one day without letting them know he's coming.
No, I get that.
How about I pick March 19th, just to make sure that he has all that Huber paperwork taken care of.
Okay.
Anything additional from the state?
No, Your Honor.
Attorney Johnin, if you can review the post-conviction rights with your client, and is there anything from your perspective?
No, Your Honor, thank you very much.
Is there any jail credit? Well, if you don't mind me asking just Mr. Oliveira directly, were you booked into the jail at all during this incident, Mr. Oliveira, or were you just released from the hospital?
I was not, just to St. Mary's.
Okay, then there's no credit on the case, I don't think. It doesn't sound like.
No, no, honestly, I was just taken to St. Mary's.
Okay.
And the officer asked me where I wanted to be taken.
Okay. Count 2 will be dismissed to clear up that record. And then good luck to you, Mr. Oliveira, and that's all on this case. Thank you.
Your Honor, thank you so much for your kindness. I do appreciate it.
Thank you.
All right, bye-bye.
And that's the end of the cases for the morning, too.